day, everyone. My name is Mabore Molepo. I'm a multi-product legal advisor for consumer, POPI, and labor in the Polokwane office.
Good day, everyone. My name is Arno Maree. I'm a multi-product legal advisor for consumer, POPI, and labor, also in the Polokwane office.
So today we're going to be talking about Section 61 of the Consumer Protection Act, which talks about the liability for damage caused by goods. Before we dive into it, Arno, can you just explain to me who qualifies as a consumer?
Yes, of course, Mabore. A consumer is defined in the Act as a person to whom the particular goods or services are marketed to in the ordinary course of the supplier's business, and also a person who has entered into a transaction with the supplier. What this means is that a consumer is someone who buys or uses goods or services from a supplier.
So basically the man on the street. Then, Arno, who's potentially liable for a defective or hazardous good?
That is a very good question, Mabore. This would include the producer, importer, distributor, as well as the retailer of any goods, as they could be liable for any harm caused wholly or partly as a consequence of any of the following. And that would be the supplying of unsafe goods, a product failure, defect or hazard in any goods, or inadequate warnings or instructions provided to the consumer pertaining to any hazard arising from or which is associated with the use of any goods. It is furthermore also important to note that this liability is irrespective of whether the harm resulted from any negligence on the part of the producer, importer, distributor, or retailer, or however the case may be.
So, Arno, what you're trying to say is that anyone who is in the supply chain of the product is potentially liable, meaning when supplying hazardous products or goods, there must be a label which indicates that this is a hazardous product and may cause harm.
That is correct, Mabore. Now, Mabore, just to add on, there's a case which deals with the specific question we have at hand. Will you please elaborate for us on the Halstead versus Eskom case?
All right. Thank you, Arno. In this case, which I call it the Eskom case, the plaintiff was riding a bicycle. There was an exposed power line. The plaintiff got electrocuted and sustained serious injuries. As a result, he instituted actions against Eskom. Well, Eskom's legal team argued that even though Eskom was the supplier and manufacturer of the electricity, the maintenance of the power line was the responsibility of the relevant municipality, and the plaintiff was supposed to institute actions against that relevant municipality. Well, the judge, however, held that Section 61 of the Consumer Protection Act is broad enough to apply to Eskom, as they are the manufacturer and supplier of the electricity and also can be held liable.
So, Mabore, it comes down to any supplier who, in conjunction with the performance of its services, applies, supplies, installs, or provides access to any goods, must then be regarded as a supplier of those goods to the consumer for the purposes of the Consumer Protection Act.
That is correct. So, Arno, we're making a lot of reference about harm caused to the consumer. What exactly does this constitute in terms of the Consumer Protection Act?
Mabore, this could be any of the following. That would be the death of or injury of any natural person, an illness of any natural person, any loss or physical damage to any property, irrespective of whether it is movable or immovable, and any economic loss that results from the harm.
So, Arno, this means that I could hold any persons or entities in the supply chain of products or goods liable for death, meaning the heirs would have a claim against any people in the supply chain who produced a good that caused the deceased death.
That is correct, Mabore. This section is far-reaching and ensures that the consumer is protected against any hazardous, defective, or harmful products. It is important to note that the consumer cannot alter any goods contrary to the instructions of the supplier or manufacturer and then lodge a claim for damages against the supplier or manufacturer and expect to succeed with the claim. This section is there to protect the consumer against suppliers or manufacturers who fail to take the necessary precautions in providing goods and products which may be harmful to the consumer.
Well, thank you, Arno. I believe what we've discussed today will clarify and inform our listeners what Section 61 of the Consumer Protection Act entails and the possible risks and liabilities a supplier, manufacturer, distributor, or retailer could face if the product or goods causes harm to the consumer.
Thank you, Mabore, for this brief discussion regarding Section 61 of the Consumer Protection Act. And should any company require any further information with regards to any consumer matter or a matter regarding Section 61 specifically, we highly recommend that you contact your nearest SEESA office for assistance.